The testimony phase of Lori-Vallow-Daybell's murder trial wrapped up much quicker than expected, with both sides resting their cases Tuesday. Today, attorneys decided on 39 instructions for jurors, and those instructions explain how those jurors should apply Idaho law to the evidence presented during this trial. Vallow, remember, is the Eastern Idaho mom charged with murder, conspiracy to commit murder, and grand theft in the deaths of her two kids, JJ and Tylee Ryan, and her husband's late wife, Tammy Daybell. And what seemed to catch a few people off guard was the defense attorney's decision to rest their case, without really much of offering a case of their own. Abby Davis has been keeping tabs on this. You talked to a defense attorney today, Abby, about this and why they may have done this.
Well, in this case, Brian, I talked to former Idaho Attorney General Dave Leroy, and he says at the end of the day, it really just comes down to strategy. Over the 5 weeks of testimony, the prosecution called 60 witnesses. Those witnesses were a combination of Lori's family, friends, law enforcement, and investigators throughout Idaho, Utah, and Arizona. The prosecution rested its case yesterday, meaning they had presented all their evidence and witnesses. Lori's defense team rested shortly after, but without calling any witnesses or presenting any evidence. They claim the state did not prove its case against Lori. Leroy says it's a common strategy, but one that's slightly considering how long this case is.
It's not uncommon that the defense would rest without calling witnesses, particularly the defendant. It minimizes the chance of any surprise or problem in the defense case because the defendant is not subjected, therefore, to cross-examination by the prosecution on any points of sensitivity. It's also a good strategy in terms of precluding the prosecution from putting on a rebuttal case, making counterpoints to whatever the defense offers.
Final arguments start tomorrow morning. After that, the jury starts deliberating. There is no time limit for that, but Leroy says he expects it will take at least 2 days. The jury has to unanimously agree. The defense also filed a motion for acquittal yesterday after they claimed the state didn't prove its case. And Leroy says the judge will most likely rule on that tomorrow, Brian.
Okay, so if the defense resting its case without presenting any testimony or evidence is not all that uncommon, how uncommon is it for a judge then to offer this acquittal without the jury doing that?
Well, Leroy actually says that is extremely rare. He says that essentially just takes away the juror's role in the court.
Right.
And he also said that it doesn't really have anything to do with the defense. The judge looks solely at whether the prosecution gave a factual basis for the charges.
Okay, so still a lot more things could happen by the end of this week. All right, thank you very much, Abby. For the latest on the trial, you can visit this story, which is on our website at ktvb.com. And for more in-depth coverage from court, you can scan the QR code on your screen right now, and we'll send you a link to all of our coverage of this trial.